Cook, Marquette, Ponder, and Wolves are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to Tell Me I Have a Case, the show where we invite you to take a second look at the world of personal injury litigation. We've been talking with Kip Robertson at Bartemus, Frickleton, Robertson, and Rader. And in segment one, we talked about the sort of bad faith litigation in car accidents, kind of how that works, how that operates, and the type of scenario where you might want to contact a lawyer like Mr. Robertson. Dan, what do we have on tap for segment number two?
Sure. So, Kip, you have a wealth of knowledge and handled a lot of cases dealing with bad faith litigation. Just tell the folks a little bit about, like, if someone's came to you, how they come to you, and where they say, hey, tell me, Kip, I got a case. Do you have a case you can talk about today?
Yeah, I do have a case. And, the way people come to me is usually one of the three things we described in the first segment happens. Either they get a coverage denial letter, they get a reservation of rights letter, or they have an insurance company that is refusing to settle the case sort of against their wishes. And so, at that point, people are put in contact with me either through friends or family or another lawyer. But just kind of one example of a case I had several years ago, and this is probably the bad faith case that stands out the most in my mind, and I'm guessing forever will. We had the opportunity to represent a school bus driver who'd retired from his longtime career and was basically driving a school bus sort of in his retirement. And he had the same route every day, same kids, and there was a brother and a sister. The sister, I believe, was around the age of 10 or so, and the boy was a kindergartner who was 6 years old. And they were the first stop on the bus driver's afternoon route. They would normally stop, get off the bus. He would wave them over, and they'd get into their front yard, and then he'd drive on. And on one particular day in the winter months, the bus driver stopped, and the brother and the sister got off the bus, and he had some sort of a disciplinary issue to deal with in the back of the bus, and looked back there to handle that, and looked up, and he saw the sister in the front yard, who usually was the second one to cross, and he started to move forward. And unfortunately, the boy was still in front of the bus, and was run over and killed instantly in front of his house. It was a terrible accident, and exactly the type of accident that liability insurance coverage is supposed to cover. So because he was a bus driver, he was insured under the policy of his employer, who was the school district. This was a mid-Missouri case. And initially, the insurance company seemed like it was doing the right thing. They hired him a defense lawyer. They started to defend him. They even started having settlement discussions with the family of the injured boy, who was represented by a law firm out of St. Louis. But they thought they could settle the case in mid-Missouri somewhere in the mid-six figures. The policy limit on this insurance policy was $2.5 million, and they wanted to try to settle it somewhere in the $500,000 range. It became very clear early on that the family was not willing to do that. Their demand was, we want the entire policy limit. We'll settle the case for $2.5 million. And if you're not willing to pay that, we're going to take this case to trial. And that's when things started to get a little bit sort of sideways with the insurance company.
And so is that about the time then they contacted you?
Not quite yet. There had not yet been a coverage denial. So here's how that played out. So there was also a prosecutor in this mid-Missouri county where the accident happened, who decided to charge the bus driver with basically involuntary manslaughter, which is a charge based on negligence. And that's important because in Missouri, negligence basically means an accident. You were just careless. And again, it's the type of thing that insurance is supposed to cover. That's what you pay for. And if you think about it, just about anything you do in a car that causes harm to somebody else could be deemed a crime, whether it's speeding, running a stop sign. There are statutes for all of those things. And so this insurance company, he was charged with this crime. They went ahead and voluntarily hired a criminal lawyer for the bus driver to represent him even though their policy didn't require that, which seemed like a good thing up front. But that criminal lawyer then told the bus driver he needed to plead guilty to the crime that he was charged with.
Oh, wow.
And then the insurance company turned around and said, now we have to deny you coverage, Mr. Bus Driver, because you've pled guilty to a criminal act.
Yeah, there are inside most insurance policies, for those of you who haven't read yours, there's something called the criminal acts exception. That will basically take coverage away from you if you are engaged in some sort of criminal action. It's really meant for an intentional crime, not as you said, you can be charged with a crime with almost any accident, running a stop sign, running a red light, driving 5 miles an hour over the speed limit. Those are all technically crimes. So what it sounds like this insurance company did was hire a lawyer, get this guy to plead guilty to a quote-unquote crime, and then use that guilty plea to pull coverage. Do I have that right?
That's exactly correct. They essentially manufactured a basis they would use to deny coverage in a case that involved the very conduct they had agreed to insure, which was a car accident.
Wow. So then I take it then that's when the bus driver got in touch with you guys.
That's when the bus driver got in touch with us and hired us. And when his with no more insurance coverage, he really had no options. And so I took over and started representing the bus driver. And we talked about in the first segment one of these contracts pursuant to this statute 537065. We entered into one of those contracts with the family of the deceased boy. And they agreed not to pursue the bus driver for his personal assets. And in turn, we agreed to pursue the insurance company for its bad faith. And any recovery we got in the bad faith case would then be used to satisfy the judgment that was entered against my client in favor of the injured deceased boy's family.
Okay. So you in effect agree to a judgment with the injured party, so long as they agree they're not going to collect any money from your client individually.
Right. And that's exactly how it works. And so they went and they presented their case in front of a trial judge, and a trial judge entered a judgment of $11 million. And at that point, our work really began, and we started pursuing the insurance company for both its bad faith refusal to defend and settle.
And so what's the process then for that action?
Yeah. So typically what happens is the judgment creditor, the person who's injured, in this case, the family of this deceased boy, will file what's called an equitable garnishment action, where they sue the insurance company to try to satisfy the judgment. And under that statute, the insured, in this case, the bus driver, is also made a party. And then, so the insured then filed what's called a cross claim for bad faith, failure to settle, and refusal to defend. So, and really the bad faith case here really kind of drove the entire thing due to the just egregious conduct of the insurance company in manufacturing its own basis to deny coverage.
Can you tell the folks a little bit about what kind of hurdles you went through to get to the end of this case?
Sure. So, I mean, the first major hurdle and one of the biggest fights we had was whether or not we would get to see the insurance company's claims file. So anytime there's a claim, the insurance company, has basically a file they create which documents and logs all the activity on the claim and all the communications that are had on the claim. And, a lot of people don't know, but they're entitled to see their own insurance company's, claim file. That's considered the insured's claim file. It's no different than a lawyer and a client. If a client walks into my office or Matt and Dan, your offices, and says, I'd like to see my file, that's their file. They have an absolute right to see it. And the law is exactly the same with the insurance company. But in this particular case, the insurance company took the position that, well, we don't want to show you our file. We think it's our work product. And so we had a very long and lengthy fight about whether we got to see that. And ultimately, we prevailed in that fight and got to see the claims file up to the date that coverage was formally denied. And, as you might imagine, when we got into that claims file and saw what the insurance company had done, it only got worse for the insurance company.
Yeah, you typically, people, insurance adjusters, most of them are really good at their jobs, but they do tend to document everything. And when you're engaged in bad faith, they tend to document that bad faith. I imagine you saw a lot of that in that file.
We did, and there was one particular claim note that really sort of sealed the deal for the case. And as I mentioned earlier, the point where the insurance company started to no longer perform its obligations under the policy was when the boy's family made it clear they were not going to settle for less than the policy limit. And so we subsequently found a claim note where the adjuster had documented a conversation between herself and her supervisors and actually another lawyer, where they conspired to come up with this scheme to basically tell the family of the boy that they either needed to come to mediation or the coverage was going to be denied. So in other words, they turned the insured's coverage into a bargaining chip to try to force this family into a mediation where they thought they would be able to settle the case for less than the policy limits. And the phrase I kept using in that case was, that is bad faith on steroids. You don't deny somebody coverage because you want to pay less on a claim.
Yeah, that's the very definition of the insurance company protecting their interest far ahead of the insureds. I mean, you can't come up with a better example of it than that.
Right. And I don't know that I'll ever see bad faith like this again in my career. It was some of the worst conduct I've ever seen out of an insurance company.
How long did that case take?
Well, they defended it very aggressively, and we litigated that case for about 3.5 years. We had 2 trips to the Court of Appeals. We won the coverage issue and established that criminal acts exclusion, Matt, that you mentioned earlier, did not apply. They appealed that. We won at the Court of Appeals, and then we had a separate appeal on sort of a in the weeds legal insurance issue with what's called a reinsurance company. But 3.5 years of litigation, and deposing all the insurance adjusters and getting the case ready for trial, and ultimately we were able to settle that case for $13 million on a $2.5 million policy.
Wow, that's a great result, not only for your client, who then had his assets protected basically at every stage of the litigation after the denial of coverage, but also ultimately for the family that suffered that tragedy.
I think a lot of folks are probably asking, why don't insurance companies just do the right thing from the get-go? Why don't they just pay the policy on their front end to avoid experiencing a judgment of this size on the back end?
Yeah, Dan, that's a good question. And again, a lot of times they do. I mean, there are a lot of good people in the insurance industry. I'm not trying to paint with a broad brush, but for whatever reason, sometimes the desire to save a little bit of money on the policy seems to take over. And, there may be some incentives in some insurance companies. Adjusters get judged on how much they pay out in claims, and that's how they're evaluated. And so they have incentives to try to, lowball or minimize the amount of the claim, even when it's not in the best interest of the party who's paid for the insurance.
Yeah. When I was doing the insurance defense, I almost never went to trial without having a conversation with the insurance company about, hey, what happens if we get a judgment above the policy limits? If I thought that was even a remote possibility that we could, get a judgment that would exceed my client's limits, I would go to the insurance company and I would say, listen, I think we should try this case. I think we're going to bring it in under the last demand that the plaintiff made. But if we don't, right, if we get that one jury out of 100 that exceeds the policy limits, I need to hear from you that you're going to cover my guy, because it's really your decision to try the case, insurance company, not his. And so you need to offer him that protection. I can tell you the company I work for every single time told me, absolutely, tell your client he's good, we'll cover him no matter what, and move forward with it. And so you're right, the vast majority of insurance companies will do the right thing. But what you need to know, if you get sued, and you've got a $100,000 or a $250,000 policy, that verdicts above those amounts do happen. And you do have rights, and somebody like Kip can help you protect your personal assets, your home, the savings you've acquired, and keep you from having to pay, that type of excess judgment.
Yeah, I'm sure when these clients come to you, I mean, their life is in a state of flux. They have a judgment against them, and then you're there to help steer the ship and protect what they got. And you mentioned that there's a contract that they can enter into. What's that contract again?
Yeah, it's called a 537-065 agreement, which that's in reference to the statute that authorizes that type of a contract in Missouri. And that's right. I mean, when those people come to me, my job is to represent them and protect them. I don't work for the injured person or their lawyer. My job is to represent my client, which is the insured. And the way we can do that is entering into one of these contracts and making sure that they are protected.
Because, I mean, I can imagine it's got to be a terrifying time for them. And when they meet with you, I'm sure there's a sense of relief, so to speak.
Yeah, they're anxious, they're scared, they're facing the prospect of potentially hundreds of thousands of dollars of debt from a judgment that they really don't have any ability to pay. They're faced with the prospect of potentially having their wages garnished.
Kip, if somebody does find themselves in this type of situation, how would they get a hold of you?
Sure, a couple ways to do it. You can go to our website, which is www.bflawfirm.com. There's a function you can use to get in touch with me there. Our office number is 913-266-2300. You can also call.
And we've been talking with Kip Robertson of Bartimus, Frickleton, Robertson, and Rader. Kip, thanks for joining us. You've been listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. For Dan Grimm, I'm Matt Glenn. Thanks for joining us.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolls today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.